there. Good morning, everybody, or afternoon, actually. As it's about noon, we're going to begin the webinar. Thank you all for attending the webinar today. My name is Jennifer Simons, and I'm with McAndrews Law Offices. I have worked in our estate and trust department for the past 11 years and been practicing in our firm for the past 7 years. So today we're going to be talking about guardianship versus power of attorney, and I'll be talking about the differences between the two and when each may be needed. And I'm going to hopefully have time at the end to answer any questions that anybody has, but I am kind of locked into an hour here. I do have kind of a hard stop at 1 o'clock. So if I don't get time to go over any questions, you can go to our website afterwards and contact us on there, and we'll be able to answer your question. But so I'm going to ask that if you hold any questions until the end, and then, like I said, if I have time, I'll answer them afterwards. If not, you can go to the website and let us know your question there, and then we'll get back to you. And you can just type your questions into the chat box. All right, so why don't we go ahead and jump in so that we have enough time to get through everything. As I said, we're going to be talking about guardianship versus power of attorney. So at a high level, I wanted to talk about the difference between the two. So a power of attorney is a document where an individual is giving another individual the ability to act on their behalf, whether it be for financial or medical type of things. You're essentially giving another person the power to make those medical or financial decisions for you. With a power of attorney, the person creating the power of attorney always has the ability to act on their own if they don't want their agent to act for them. They always have the ability to act on their own, and they have the ability to revoke the power of attorney document in the future if need be. If they decide that they don't want that person to be their agent anymore, they can revoke the power of attorney and do a new one. Guardianship, on the other hand, is a legal process through the court where you're asking the court to determine that a person is incapacitated and to sometimes appoint a guardian to act on their behalf. A guardianship is typically only needed if a person has not previously executed a power of attorney document and a guardian is needed. And I'm going to go through guardianship in a lot more detail, but I did want to mention that there had been changes to the Pennsylvania guardianship rules that went into effect on June 11th. So they're, fairly new changes that went into effect. I'm going to touch on them a little bit when I talk about guardianship. I'm not going to go into a lot of great detail because they are relatively new changes, but I will let you know what they are, and we'll talk about them a little more in detail towards the end of the presentation. But again, guardianship is typically only needed if somebody has not already executed a power of attorney and they're determined to be incapacitated later, and if they need a guardian to act on their behalf, meaning that there are no other less restrictive alternatives to doing a guardianship. So power of attorney versus guardianship is, like I said, there's different times and different situations where you may need guardianship, but courts generally prefer a power of attorney over a guardianship. And again, you always want to think about what would be the least restrictive alternatives before you petition the court to have a guardian appointed and to have somebody be declared incapacitated. A couple legal terms when I'm talking about a power of attorney, in case people aren't familiar with these terms. When I refer to the principal, I'm referring to the person creating the power of attorney. and the agent is the individual that they're appointing to act on their behalf. Okay, so what is a power of attorney? As I said, it's a written document where an individual is giving another individual the power to act on their behalf. And the power of attorney document itself will determine what type of powers the agent has over the principal. Different powers of attorney are drafted differently. They include different powers. Typically, when we do a power of attorney in our office, we try to draft it as broadly as possible most times, so that the agent has the ability in the future that they have the power to whatever type of power they need in order to act on behalf of the principal. You can have a couple different types of powers of attorney. One would be a financial only power of attorney, where the agent would only have the ability to handle the financial affairs of the principal and to handle any type of financial transactions on their behalf. You can have a healthcare power of attorney only, meaning that that agent would only have the power to make healthcare type decisions for the principal. And then you can have both, a combined financial and medical, where that agent has the ability to make both healthcare and financial decisions. Typically, I'm usually with clients most times doing a combined power of attorney. And generally that's when you're appointing the same agent. You want to have the same agent handle healthcare and financial. There are times when a client may have an adult child who they want to appoint as their financial power of attorney because maybe their child is a financial advisor, and then they want to have another child who's maybe in the healthcare field. Maybe the other child is a doctor and they want that child to make healthcare decisions. So in that case, we would do two separate documents, a financial and a healthcare, that would be separate if you're naming different agents for those different roles. As I said, the principal always has the ability to act on their own, and they can revoke the power of attorney at any time. So in order to create a power of attorney, the principal has to have capacity. And capacity is a little bit hard to define. There's not really an exact definition in regard to having the capacity to do a power of attorney. But in general, the person needs to have a general understanding of what they're doing. They need to be oriented to person, place, and time. They need to know, what is the date today? Where do they live? Again, understanding that the document that they're signing is appointing another person to handle their money or to talk to doctors for them, to make any type of healthcare decisions on their behalf. So they need to have, that minimum level of understanding what the document is and what is the type of power that they're giving to another person. And then there are also two other different types of a power of attorney document. One being a durable power of attorney. And what that means is that that document will remain in place even if the principal is later determined to be incapacitated. The document would remain in place and their agent would be able to continue to act on their behalf. All power of attorneys in Pennsylvania are presumed to be durable unless the document itself states otherwise. And that would be the other type, which would be a springing power of attorney. And in that document, it would have language stating that that document would only go into effect once a doctor has certified that the principal is incapacitated and that they are not able to make their own decisions. I would say that typically most powers of attorney are going to be durable because you usually want the agent to be able to act immediately if need be. If you have a power of attorney and you're going on vacation and maybe you're not incapacitated and you're not incompetent, but maybe you need your agent to handle something for you while you're on vacation. You're unable at that time to do it. With a springing power of attorney, that agent wouldn't be able to act on your behalf because you're not incapacitated. You're not, you're still competent, able to handle your own affairs. So the problem with the springing power of attorney is that there can be a delay in time from the time that a doctor certifies that somebody is incapacitated to when the agent would then actually be able to act on their behalf. But I just wanted to just touch on the two different types of power of attorney. In the power of attorney document, you're going to list the type of powers that you're giving to your agent. Like I said, we typically draft ours pretty broadly in order to give the agent the powers that they might need. Some typical powers that I've listed here are for a financial power of attorney, to engage in any type of banking or financial transactions, to be able to handle your bank accounts, to, write checks on your behalf, to pay your bills, to do anything having to do with your finances, to create a trust for your benefit if need be in the future, to handle any type of real estate transaction, to make gifts on your behalf if need be. Sometimes if people are doing Medicaid planning, they may need to do gifting to be able then to have your agent be able to make those gifts on your behalf. And then, to any other type of transaction, whether it's to apply for government benefits on your behalf, to, again, like I have listed, pursue any type of tax matters, to handle any type of tax issues that come up. And then in terms of the healthcare power of attorney portion would be any type of healthcare decisions, making arrangements for your funeral, burial, maybe, purchasing a prepaid funeral for you, authorizing admission to whether it's a hospital, a nursing facility, or assisted living, any type of facility like that. They would be able to authorize your admission, and of course to authorize any type of medical or surgical procedures on your behalf. Again, only if you're unable to do these things on your own. And then another type of power that we added in the past few years to our power of attorney documents is the ability of the agent to be able to access any digital accounts, electronic accounts. Nowadays, a lot of people are banking online, and you may want your agent to be able to access those accounts if need be, and go into your social media accounts if need be, whether to cancel those accounts or do anything on your behalf. So we now include those powers in the power of attorney document for the agent to have those. When you are an agent, you always have the responsibility to act on behalf of the principal. You need to act in their best interest at all times. You need to use prudence and make sure that you're handling their assets prudently, keeping your assets separate from the principal. You never want to combine your assets with the assets of the person who you are, who's the principal, who you're acting on their behalf. You never want to commingle any assets. Keep all of their assets separate. And then most of all, keep accurate records of anything that you're doing on behalf of that person, especially financial. Keep all receipts. Keep a record of anything that you're doing on their behalf, just in case in the future you would need to account for that in any way. It's always pretty important to keep a record of everything that you're doing as somebody's agent. So that is essentially what a power of attorney document is. And again, this is typically needed to avoid guardianship being needed in the future. We tell clients that really everybody should have a power of attorney document so that guardianship is not needed in the future. Most times, if you signed a power of attorney document, then hopefully that would avoid any type of guardianship proceedings. But if that hasn't happened, if somebody has not executed a power of attorney document, and if they later start having issues where they may be incapacitated, and if they haven't signed a power of attorney document, then that's where potentially you may need to pursue guardianship through the court. And as I said, the law has been changing. In the past several years, the law in Pennsylvania for guardianship has been changing a little bit, and it's really coming out of the courts wanting to protect all individuals and to make sure to preserve their rights whenever possible. And so the courts really want to try to avoid having a guardian appointed for people if it isn't absolutely necessary, and that there are no other less restrictive alternatives available other than guardianship. And again, I'm going to go into a little more detail about that, but that is, I have the guardianship statute up here on the screen, but I just wanted to go into a little more explaining how, the law has been changing a little bit in the past few years. And it's the courts wanting to protect every individual's right and allow people to make decisions on their own to the extent that they're able to. So when you are pursuing guardianship through the court, you are asking the court to determine that an individual is incapacitated, and sometimes whether or not they need to have a guardian appointed for them. It's really a two-step process. One is, are they incapacitated? The court will first make that determination whether they're incapacitated, and then whether, if they are incapacitated, do they need a guardian? It's really two different questions. So I'm going to go into the process of filing the petition, what is needed, and then go over what would be less restrictive alternatives, the things that you would want to think about before filing a petition, or to put into your petition why maybe the less restrictive alternatives won't work. So I'm going to go into all of that. But so guardianship, again, is where we're asking the court to determine that somebody's incapacitated. And I have the definition of incapacitated is, somebody whose ability to receive and evaluate information effectively and communicate decisions is impaired to an extent where the person's unable to manage his or her financial resources or to meet essential requirements for his or her health and safety. There are a couple different types of guardianship. One is a guardianship of the person, and that means that the guardian would only be pretty much making all decisions other than financial for that person. So healthcare, decisions about where they would live, all of those type of things other than financial. And then the guardian, if you have a guardianship of the estate, then the guardian is making any type of financial decisions, handling that person's assets, whatever assets they have. The guardian of the estate then would be the one handling those. A plenary guardian, if a plenary guardian is appointed by the court, that means that that person is a guardian of the person's estate and of their person, meaning they have total decision-making authority. And again, this is only, the court's only going to appoint a guardian if it's determined that the person needs a guardian. Even if they're incapacitated, they may not need a guardian if there are other ways to handle the person's money or to make any other type of decisions for them. You can also have a limited guardianship, which is really what the courts prefer when possible, where you're really limiting the types of decisions that a guardian would make. And in all other areas, the alleged incapacitated person, the AIP, they would retain their ability to make all other decisions. So here is where the court is kind of carving out what decisions a guardian would be making, like very, very specific, not just all financial or all personal. This is where there are like very specific things that a guardian would be handling. So it can be a little more challenging because again, you're having to kind of carve out what are those types of decisions that only the guardian can make, and everything else the AIP would be able to make on their own. And then you can also have an emergency guardianship. I would say this does not happen very often because it only happens where you are having to show to the court that unless the guardianship is put in place, then there will be irreparable harm that would come to the alleged incapacitated person. With an emergency guardianship, that only remains in effect for typically 72 hours. Sometimes it can be extended, but after that time, then you have to go ahead and do a regular guardianship after that. So again, it doesn't happen very often, these emergency guardianships, because you do have to show that there would be irreparable harm if that guardianship isn't put in place right away. So we get a lot of clients who ask who can petition the court, who can ask that a guardian be appointed for another person. And it's not just family. A lot of times people think that only a family member can petition the court. Really, it's anybody who has an interest in the alleged incapacitated person's welfare can petition the court if they feel that a guardian needs to be appointed. That person, of course, cannot have any interest that would be adverse to the person, but anybody who has an interest in their welfare, and it could be an individual or it could be an agency, if they feel that this person needs to have a guardian appointed for them. So in order to have a guardian appointed, have somebody be declared incapacitated, you need to file a petition with the court. In the petition, you're going to put basic information, the name, who the alleged incapacitated person is, their date of birth, their next of kin, who the proposed guardian is, information about the proposed guardian, what type of disability the AIP has, what are their assets, have they ever done any other type of estate planning documents, have they ever executed a will or a POA. And then most importantly, and this was one of the changes that just went into effect on June 11th, is the court is requiring very specific information in the petition as to what other alternatives have been considered before deciding that you need to petition for guardianship. You need to tell the court, are there any other less restrictive alternatives available, and why those alternatives will not work here, or if you've tried them and they didn't work. The court is going to put a much greater emphasis on these less restrictive alternatives and why they're not available and why you are requesting to have a guardian appointed. Again, there's the question of whether somebody is incapacitated, and then there's a separate question of if they are incapacitated, do they actually need a guardian, or are there other ways that their assets can be handled or decisions made on their behalf. So that needs to be in the petition very specifically. And then also any qualification of proposed guardians, I would say that's typically more when you're appointing a corporate guardian in agency. What are their qualifications or certifications? Every proposed guardian, you need to submit a background check, a criminal background check on them to make sure that they don't have any, criminal background. So when I talk about less restrictive alternatives, I wanted to go into that a little bit more in detail and talk about what some of the alternatives would be. So in regard to a guardian of the person, some other alternatives could be, did that person already have a healthcare power of attorney in place? If they already have a healthcare power of attorney, then you may not need a guardian of the person. If that agent is able to, act for that person and make those type of healthcare decisions, that would be an alternative possibly to a guardian of the person. Same thing if they had a living will. So a living will is where somebody um, basically sets out what type of treatment they would want in an end stage medical condition. So if somebody has already executed a living will, then that whoever is appointed as their healthcare agent living will would be able to make those type of end of life decisions for them. Another alternative is in Pennsylvania, there is a healthcare representative statute. And going to go into that a little more detail in the next slide or two, but that law already gives in a priority order, it sets out who could be essentially a healthcare agent for somebody who does not already have a power of attorney or a guardian. It's a priority order of the people who would be able to, under that statute, be able to make healthcare type decisions for the person. So a lot of times, that may be an alternative to having a guardian of the person appointed. If you have, somebody who could be their healthcare representative under the statute, that they may not need then a guardian of the person. And then there's also something called supported decision making. Not every state has actually enacted that, but Delaware has, Pennsylvania has not yet. But that being said, there are ways to help people make decisions. If they have somebody who they trust, they can help them make decisions. And that can sometimes be an alternative also to having a guardian appointed. So this is the healthcare representative statute I was referring to, where it gives a list of people in that order who would be able to make healthcare decisions for a person if they didn't already have a power of attorney or a guardian appointed for them. And I just go through examples here of if in that order who under this statute would be able to make healthcare decisions. And then in terms of alternatives for a guardianship of the estate, a couple examples here are a financial power of attorney, in the same way that healthcare power of attorney would be an alternative to the guardian of the person. A financial power of attorney, if somebody already has a financial power of attorney, you may not need a guardian of the estate because presumably the agent under the power of attorney would be able to handle the assets and handle any type of financial transactions. If all of the person's assets are in a trust, like a special needs trust, and they don't have any other assets that need to be handled, then again, you may not need a guardian of the estate because the trustee would be the one being able to handle all of those assets that are in the trust. If the person has an ABLE account, then there can be a person who would be able to manage that ABLE account for them. So if they don't have any other assets and everything is in an ABLE account, they may not need a guardian of the estate. And then if somebody is receiving Social Security benefits, you can have a representative payee appointed for that person. If they're not able to handle and manage their own money, then Social Security will appoint a representative payee for them. And that could be in lieu of a guardian of the estate. If there are no other assets that need to be handled other than their Social Security benefits, then you could always have a representative payee handle those. And then the I was just referring to in the prior slide, the supported decision-making, where you have a trusted friend or family member who would be able to help that person with any types of, whether it's, I gave examples here of a shopping, paying bills, somebody who can help them, can possibly be an alternative. And I just was talking here a little more about supported decision-making. Again, it just allows a person to turn to a trusted friend or family member in helping make any type of decision that they need help with. It helps them to be able to retain their individual rights to make their own decisions, but maybe with help from another person. And here they still would have the ability to, make their own choices, but just that they would get help from another person. As I said, Pennsylvania has not actually passed a specific law providing for supported decision-making. Delaware has. But again, it's a possible alternative to guardianship. So assuming that you looked at all the alternatives and maybe none of those alternatives work, maybe the person has not executed a power of attorney already, and now they don't have capacity to do that. Or, maybe they don't have a trust and they have, money in a bank account that needs to be handled by somebody. They're not able to do it. So if you looked at all the alternatives and you decided that there's really no way to help this person and to handle their money or make medical decisions on their behalf, then you're going to go ahead with filing the guardianship petition with the court. So the petition would be filed in the orphan court of the county, wherever the alleged incapacitated person is either domiciled or resides. So wherever, it is that they call home, or wherever they happen to be physically living. It can be in either of those counties. After you file the petition with the court, then the court is going to issue a citation to the AIP. And it's really letting them know that a petition has been filed and that the petitioner is asking that they be declared incapacitated, and to either, you may be asking for a guardian to be appointed or you may not be, but the citation lets them know that there'll be a hearing, that they have a right to attend the hearing, they have a right to have their own counsel, which now, again, under the new rules that just went into effect, the court will now automatically appoint counsel for an AIP. In the past, there were times when a court might appoint counsel. It just really depended on the specific situation, but now they will automatically be appointing counsel for every AIP. So the AIP needs to be personally served with the citation, with the petition, with the preliminary decree that sets forth the date, time, place for the hearing. And they need to have that explained to them in terms that they can best understand. A lot of times, if somebody is incapacitated, they might not be able to read that citation and understand the petition, but you have to try to explain it to them when you're serving them in terms that they can best understand. And any next of kin, intestate heirs, also need to be provided with notice of the petition and hearing, as well as any residential providers if the person's living in a residential facility. So the petition, the citation, the preliminary decree, they have to be served on the AIP, the alleged incapacitated person, and on their intestate heirs, next of kin, within at least 20 days prior to the hearing. And again, explain it, like I said, in language that they're best able to understand. You have to file a proof of service with the court, letting the court know that they were personally served within 20 days. And then the court will schedule a hearing. So there'll be a hearing, and it's going to be held in front of a judge. And at the hearing, the petitioner needs to present evidence that the person is incapacitated. You're asking the court to determine they're incapacitated. So you need to present evidence at the hearing, which is going to be evidence from typically from a medical professional, a doctor, psychologist, psychiatrist, or somebody who is an expert in that area in terms of determining whether somebody's incapacitated. So it doesn't necessarily have to be a doctor. It could be there are times when it may be a nurse practitioner. So anybody who is an expert and is able to make that determination could be the person who's giving the medical testimony. And it can be done either with the doctor being present at the hearing, but it can also be done through an expert report that is used in Pennsylvania, that the doctor or the expert, whoever's completing it, they would fill out this report. Again, it's a uniform report used in Pennsylvania that's completed, and then you would submit that with your petition to the court as evidence that the person is incapacitated. So the expert who's completing it will answer questions and give their opinion as to whether they feel that this person is incapacitated, what types of help they need, if they need a guardian, if in their opinion that they would need a guardian to handle their affairs. At the hearing, the alleged incapacitated person, the court wants to have them at the hearing whenever possible, other than a doctor stating that they should not attend the hearing because it would be harmful to them. Other than that, the court will want to have that person present at the hearing. The standard for determining somebody's incapacitated is clear and convincing evidence. So like I said, you're going to have to present testimony, whether in person or by that expert report by somebody who's qualified to make that determination and evaluate somebody and determine if they're incapacitated. And I just here is just a slide. I'm not going to go through this whole slide here, but basically it just explains what the court is going to look at and consider when they're making that determination of whether somebody is incapacitated and they're not able to make and communicate their own decisions. And they're going to then decide if a guardian then needs to be appointed. If they're incapacitated, then do they also need a guardian? Again, it's a two-step process here. Again, the courts are going to want to make sure that there are no other less restrictive alternatives available before making the decision of whether they need a guardian. At the hearing, the proposed guardian will most likely need to give testimony, basic information, their name, their address, what is their relationship to the alleged incapacitated person. They'll ask questions about their, the person's functioning, what assets they have, what public benefits they're receiving. Have they ever executed any estate planning documents in the past? So the guardians are going to have to typically give testimony during the hearing. So then the court will decide, the judge will make the decision of whether that person is incapacitated and then whether they also need a guardian. And then the court will issue an order. And if the court does, feel that the person's incapacitated and that they need a guardian, then they're going to sign an order stating that. At that point, the person who's been declared incapacitated, they do need to be noticed and served with that order and let them know that they have a right to appeal that order if they choose to do so. They also have a right to request a review hearing after the initial hearing. If things change, if the person, is later regains their capacity, then they have a right to request a review hearing for the court to review the guardianship. And that is also part of the new changes to the statute, is that now the court will automatically schedule a review hearing within 1 year of the initial hearing if the evidence shows that it's possible that the capacity of that person could change. For instance, sometimes people may have had some type of injury where, you know, they were incapacitated, and then maybe they get better. I have had, you know, cases where a client has gotten better and we've requested a review hearing to terminate the guardianship. So that can be requested anytime that circumstances change. And again, now it will be more routine. The court will automatically schedule that review hearing if the evidence shows that it's possible that the person could regain their capacity or circumstance could change. A couple of the duties of the guardian of the person would be, again, always acting in their best interest. You want to try to involve that person as much as possible in making their own decisions. You always want to, you know, involve them as much as they can. And then, you know, as guardian of the person, you're basically making decisions about their health, again, where they live, any type of decision regarding their personal welfare. And as guardian, you are required to file annual reports with the court, both guardian of the person and of the estate. You have to file reports with the court, just letting the court know every year whether really have there been any changes. You know, have they moved, or are they living somewhere different now? Has their health changed? Those type of things. And then just some examples of the duties of the guardian of the estate. Again, always acting in their best interest, protecting their assets, managing their assets, paying whatever needs to be paid, you know, bills, that type of thing. And again, you have to file an annual report with the court if you're a guardian of the person. Every year on the date that the original guardianship order was signed, on that date every year is when those reports are due. And then also when a guardian of the estate is appointed, the guardian needs to file an inventory within 90 days of the date of the order. I'm just going to touch briefly on guardianship if it needs to be transferred to another state. If the AIP moves, if, you know, the guardian moves them to another state, there is a process to transfer guardianship if need be to the other state. The rules are really vary from state to state. There is a uniform adult guardianship and protective proceedings jurisdiction act, which basically gives a process for states that you know, recognize that uniform act. And it's really a 4-step process. I'm not going in the watching our time here. I'm not going to go through the whole in a lot of detail, but you're basically filing a petition requesting that the guardianship be transferred to another state. You give the reasons why. Then the court would issue an order provisionally transferring the guardianship to the other state. Then you need to typically have an attorney in the other state file petition stating that they accept the guardianship. Again, I'm not going to go into detail here in the interest of time, but there are ways to transfer guardianship from one state to another. And I just wanted, again, to touch on the changes that went into effect on June 11th. I pretty much talked about them throughout the presentation here, but I wanted to just kind of go through each one. The first change being that now there will be an attorney appointed for every alleged incapacitated person. When the petition is filed with the court is automatically going to appoint counsel on their behalf. If they don't have money to pay for that, then the county would pay for that attorney to represent them. Another change that I really didn't touch on, because it's really, usually this would only be, I think, when you have a corporate guardian or, guardianship agency acting as guardian, but any proposed guardians who are looking to be guardians of 3 or more people, they need to be certified. The biggest change, and the most important one, I think that I've gone through it a lot in this presentation, maybe too much, but is the courts putting, that greater emphasis on less restrictive alternatives. You really need to put in the petition, what are the alternatives that you've considered, why they will work, why they won't work. Just be able to kind of justify why you're asking that a guardian be appointed. And then the last change is the one that I just talked about a few moments ago regarding a review hearing, that the court will now automatically schedule a review hearing within 1 year of the original guardianship hearing. If the evidence shows that it's possible that the person's capacity could change, or that there may be a change in the future. So that will be now just automatically scheduled within a year. Okay, so I think I got through this with a little bit of time left, about 10 minutes, or I may have to sign off a little bit before 1, a few minutes before 1. So I am going to open it up. Let's see if we have any questions.
I don't believe there's any questions, Jen, but if anybody does want to contact us via our website at McAndrewslaw.com, there's a contact us link there to send anything.
Yep, great.
Well, thank you so much.
No problem. If, like Ali said, if anybody has questions, you can contact us through the website. Hopefully this was informative to everybody, even if you learned, maybe 1 or 2 things you didn't know.
Have a good one. Thanks.
Thanks, everybody.